This is a very important phase of the criminal court process because it actually begins the trajectory of the remaining phases. And what I mean by this, those folks that are at this stage are accused of committing criminal offenses, but yet bail may be set too high or bail may be denied, but they do not have the resources to afford to buy their freedom at this stage. Those that do not have the freedom, those that do not have the resources to buy their freedom at this stage are often forced to accept plea bargains at a higher rate, being found guilty in trial outcomes at a higher rate, and they often receive harsher sentences. So understanding this process in this first phase has a huge, significant impact on the day-to-day lives of those that are accused. And I really want to stress accused at the first phase of the criminal court system. Immediately after arrest in most jurisdictions, you have a 24-hour to 48-hour period where you constitutionally afforded the right to go before a neutral magistrate to determine whether or not you should deserve to be released and the conditions of those released. Maybe about 40 years ago in the 70s, there was a second component added to this conversation that was relative to the dangerousness of the community. So now we see a number of jails with overcrowding due to a number of these decisions that we're going to talk about today. Now, most of the literature has focused on the later phases, as I mentioned earlier, of plea bargains, trial outcomes, and harsher sentences that kind of force most of us as researchers to examine how do we get these disparate outcomes. So now we see the opportunity to investigate unequal treatment based on disparity and how may race and class have an impact on these later phases. What I'm here to do today is have a conversation with you about how race may be a part of these processes before we produce these disparate bail outcomes. To acknowledge those that have done the majority of the work, even though it has been a limited amount of work, what I would say understudied in the crime and law literature, most of those have actually studied just on the outcomes, whether or not one has been released or one has been detained at this phase. Secondly, they ignore that there may be some procedural processes that may contribute to some of these outcomes. Secondly, most researchers focus their interest on the case level, the individual characteristics of the accused, race, class, and gender, not acknowledging that there are more variables included in the conversation by stepping outside of that space to look at those that are involved in these decision-making processes. One would assume that there's a single decision maker at this process known as the magistrate or the judge. Actually, there are a number of more actors involved in these processes before you even get to that bail outcome phase. And thirdly, most researchers have used quantitative data provided by government sources to investigate the probability and the likelihood of who deserves bail or not. So, with that being said, my research question is, to what extent are black males disadvantaged in the pretrial process in Atlanta and Philadelphia? What I did is I looked at two large urban cities with a high concentration of blacks, with some similar demographics on unemployment, income, but also going on the legal side, more of a structural comparison. They both have overcrowding issues in the jails, and most of those that are detained in these jails are black men. I also wanted to know what type of structure do these two different cities have that produce these disparate outcomes. So I looked at quantitative and qualitative data, just as some of my other scholars have, SCIPS data, but also know that there were some other components that will be included in how these processes actually work, which brings in the conversation of doing some courtroom ethnography as well as some in-depth qualitative interviews with those that are involved in these processes to actually gain their perspectives on how they actually play out their individual roles at each phase. The pretrial process to be, for example, immediately after that 24-hour, 48-hour period where you go before that magistrate, there usually is an interview where information is collected about your community ties as well as your legal variables based on your criminal justice history, seriousness of the offense at time of arrest, as well as your flight risk. Courtroom work group members. As mentioned earlier, the individual roles at each phase. How do you do your job that starts this trajectory to produce these disparate outcomes, which is what I really wanted to investigate. So here's a little bit about my research design. I mentioned earlier that I did look at some SCIPS data, but I did ethnography in both cities. I basically to a point of saturation because they do become very systematic after a while. So I spent a month in Atlanta. As you can see, there were more social control agents involved in Atlanta, such as courtroom, the pretrial services, spent time with bail bondsmen, and the clerk of court's office. Philadelphia doesn't have as many agents involved in their bail process, so I spent time doing observations in the courtroom and with the pretrial services. From this data I collected, I created some type of a data set so I could actually produce some numbers on what I actually observed in the courtroom, try to give a little more meat to the conversation. In Philadelphia, I wasn't able to interview as many of the courtroom actors, and this was at the request of the municipal court judge. Her quote was, "Every time someone studies Philadelphia, we can't ever seem to get it right." Yeah, so that really had the old brain thinking there, and she actually picked the magistrate that I was allowed to interview, but they did allow me to do my courtroom ethnography with more than one magistrate, so I was able to get good ethnographic data, but the former interviews were limited to only one. So, why Atlanta and Philadelphia? I mentioned some of the demographics to try to set the stage of understanding some of the similarities with who actually lives in the city. But let's talk about some of the legal comparisons between the two. Atlanta has a statute on their books known as 7 deadly sins. And no matter what criteria, risk assessment criteria is used at later phases, if you are arrested for one of those charges, you are automatically denied bail and your name goes on to the Superior Court bail hearing list 2 weeks later. Keep in mind, these are accused people at this stage. Philadelphia only has one, which is capital murder. In Atlanta, the bail procedures are much more substantive, rational way of looking at it. They are very loosely structured. And what I mean by that is these hearings actually take place in a courtroom with actual courtroom work group members being present in that space. Philadelphia is much more different. They actually have created a more formal type of pretrial process where there actually is a bail matrix that is a quantitative computerized mechanism where information is put into this matrix and it actually produces a bail recommendation, whether or not one deserves to be released without funds, as well as a financial dollar range. Also the location of where these hearings are held. In Atlanta, these hearings are actually held at the detention center, at the jail. So the jail is connected to the courtroom, which I'll talk about in a minute why that has an impact on this conversation. But in Philadelphia, the accused are detained in 7 local district detaining facilities, and bail hearings are actually conducted in downtown Philadelphia at the big courthouse on closed circuit television. So you don't have the accused in the courtroom or courtroom work group members like you do in the city of Atlanta. And bail recommendations, I previously mentioned that, more like a traditional setting. You have assistant district attorney, you may have a public defender or private defense attorney, you're going to have a pretrial services rep, and you're going to have a magistrate actually in the courtroom along with the accused having these negotiations, making recommendations, which leads to the ultimate decision on whether or not one should be released. And again, Philadelphia, it kind of felt like being in a church pew when I was doing my research. There was the only people present in the room was the magistrate, his or her clerk of court, one representative from the state, and one representative from the defense. And because of the computer bail matrix, there wasn't that much legal discourse, so that whole space was very different from what one would assume a traditional courtroom structure would look like. The last point about a comparison, there are no bail bondsmen in Philadelphia, but there are bail bondsmen in Atlanta. So from this research I gained that there were 4 domains that I want to talk to you about today that were very salient in my research: perceived threat, risk assessment criteria, barrier release determination, and interaction. So, perceived threat. Most of us are familiar with this literature about knowing that young black men are often identified as being more violent, being more criminal, and these stereotypes are reinforced by the arrest rates, by being found guilty more often and receiving harsher sentences. But there's also a role that the media plays in this by pushing some of these stereotypes on us on television as well as in the newspaper. While conducting my ethnographic work in Atlanta, a gentleman, 6'3", 250 pounds, was arrested for doing a traffic stop. Had a long criminal justice history, goes up before a bail hearing, but he didn't make it within the 24-hour period, and because of Atlanta's structure, they had to guarantee him a signature bond, which means he did not need any financial support to get out. A week later, he was pulled over by a Georgia state trooper, and he shot the state trooper in the head and killed him. So the media really came down on the criminal court system and the magistrates that are making these decisions without acknowledging that judicial authority, discretion, had no impact in that decision. And what you see here, from my last quote here, is that political pressure that puts on these judges from this media response of, you're the accused, not going to have my name in the newspaper. 85% of my sample in Atlanta were black men. So imagine being in that space, and each and every time a young black man was coming up, this was the attitude that I am not going to be the one that they write about, which often led to more punitive decisions. Just to add on, black female public defender, she really stressed the whole conversation about race and being in this space. If it's a young white woman, they're thinking you don't belong here. You're in the wrong place. White boys, you don't belong here, honey. I've heard judges say to them, look, you don't want to stay here and be up on the 7th floor, which is the most dangerous section of the Fulton County Detention Center. Risk assessment criteria. Going back to that conversation, that first interview with pretrial services, they're asking questions around education, employment, residential stability, income, references, and socioeconomic index. There's nothing wrong with these questions, but that information is used for a point scale which contributes to that recommendation about your release. So this information also has to be verified through telephones. We're talking 55% of my sample in Philadelphia was unemployed, 83% of my sample in Atlanta qualified for a public defender, which means that they make less than $1,500 a month. So to use employment income as a variable to gauging your flight risk, I challenge this notion of risk assessment criteria if it's really serving the purpose of ensuring one's appearance in court. Also, landlines. A lot of these folks do not have home phone numbers, and you're asking them to verify this information by calling references. Not exactly sure if the social capital that we share in this room would be the same type reference that they would have to impress upon this community justice agency that they would be insured to come home, show up in court. And we're talking about those that have been marginalized by a criminal justice system for a very long time. Why would one assume that they would be very trusting to be honest and share this information? I wouldn't want my employer at Delaware State University to know that I just got arrested and I do not share the same issues that this community does. Just a quote from one of my magistrates in Atlanta. I'm more likely to release a young person into the custody of their parents when I see that the parents are middle-class individuals, a good neighborhood where there's likely to be some home values and that mom and dad are going to be willing to put their foot down. Now the truth of the matter is that white people are more middle class in Fulton County than black people are. So I don't want race to be a consideration at all, but I do think it's appropriate to consider the lifestyle circumstances of the family that's involved. If they live in a nice neighborhood, whether it's southwest or north suburbs or wherever, that probably means that I'm more lenient statistically to white kids. Please note, I do not want this to be about race at all. I think this underscores the conversation about those values based on that risk assessment criteria that they're using to gauge the accused at this point, and this clearly shows that this disadvantages black men. Bail release determination. I mentioned earlier there's a traditional style of open courtroom recommendations and decisions being made. Philadelphia has a closed circuit television, and these bail matrices were created to reduce judicial discretion, which would hopefully not rid, but at least reduce discrimination on race, class, and gender. But we find out that these bail matrices are outdated. They hadn't been updated in 15 years, which allows the judges to be empowered with judicial discretion, going back into the same position to be discriminatory, which is why they had this formalized system in the first place, but it still doesn't actually work. So what do we see? White female public defender in Philadelphia says, it is an instance where judicial efficiency has trumped the rights of the individual. They do not have to be regarded as human beings because they're really on a TV, and at any time the magistrates can push the button and turn them off. And they've done that. I've seen them do that. Really stating the issues with this closed circuit television and not being present in the courtroom kind of dehumanizes the accused, makes them more of a television program. Interaction. Also in this space, there was a variable that I noticed, that how much the accused are afforded interaction with the magistrates. Here we have a white female public defender saying, but what I see generally is that younger African American men do not know how to present themselves, and it is held against them in a very large way, that they don't speak well, that their initial words out of their mouths, if they're trying to say anything for themselves, are often not phrased in a way that a magistrate is going to respond to positively. If they try to be respectful, it sounds very street. It sounds like something that they would say on the street. And the magistrates tend to reject that out of hand, and I think that ends up being a racial and cultural issue. Another disadvantage to having those accused of crime actually engage in legal discourse and not really be trained on the language totally disadvantages them in Philadelphia at this phase. So what we do have is we have two systems with different approaches in how we actually process those accused at this initial court appearance. We have Atlanta, which is much more substantive, much more traditional, much more open courtroom recommendations and decisions. And then we have Philadelphia that has done much more of a formalized system where they've tried to reduce some of the disparity and created a structure of computerized bail matrix. But at the end of the day, I have shown you that both of these systems produce very similar outcomes, which are all disadvantage to black men. Thank you.